Hearing of the appeal, Stanford International Bank Limited against HSBC Bank PLC.
Mr. Barker. May it please my lords and my lady, I appear with Mr. James Knott for the appellant, Patricia Robertson QC leads for the respondent, assisted by Louise Hutton QC and Christopher Langley. This appeal arises out of the application of the respondent HSBC to strike out SIB's claim, alternatively for summary judgment. SIB's complaint in the proceedings is that monies that were paid out from its accounts with HSBC should not have been paid out, and it claims as its loss the amount of the money so paid away. And the court would appreciate, from having read the written cases, that the payments out were made pursuant to SIB's operation of a massive Ponzi scheme. Now, in response to the claim, HSBC puts forward a number of legal and factual defences, but we are concerned today with only one of the defences, namely that which was the basis of its strikeout application. And the basis of the strikeout application is that SIB did not in fact suffer any loss because, it was said, the payments from the accounts were used to discharge valid debts of SIB. Now I propose, first of all, to make good my submission that the issue today is a very narrow issue, because it is important in my submission not to confuse that issue with the other legal defences that are being raised by HSBC. I will then address the issue of whether there has been a loss, and finally I'll say just a few brief comments dealing with the indirect customer payments. Now, dealing first of all, therefore, as to the precise issue before the court, it is perhaps helpful to remind ourselves that a number of issues arise in the context of a tortious claim, as was recently considered by this court in the Manchester Building Society and Grant Thornton case, which you have in the electronic bundles at page 949. And in the judgment of Lord Hodge and Lord Sales, if we could look at paragraph 6 first of all, on page 953, we see there immediately before the numbered subparagraphs, when a claimant seeks damages from a defendant in the tort of negligence, a series of questions arise. First, is the harm actionable? 2, the scope of duty question. 3, the breach question. 4, the factual causation question. 5, the duty nexus question. And 6, the legal responsibility question. And this appeal, in my submission, might be said to rise out of an antecedent question, which is whether there's been any loss at all. And in that context, we direct attention to what is said in paragraph 12 of the judgment on page 955. I'm reading from the 4th line in paragraph 12. It is generally more appropriate to examine this after first ascertaining, that's the questions about the extent of loss, that's first ascertaining on a simple but-for basis what is the extent of the loss which has flowed from the alleged breach of duty. Proceeding this way means that one identifies the losses which are in fact in issue, so that it is possible to focus with greater precision on the extent to which they fall within the scope of the duty of care owed by the defendant. And then at the end there, as Lord Nichols of Birkenhead explained in My Credit Mortgage, one begins by identifying what he called the basic measure of the claimant's loss, and what Lord Hobhouse described as the basic loss which the claimant has suffered i.e. the loss, which can be identified as flowing from the alleged breach of duty, is a matter of but for factual causation, and then examines the extent to which that loss falls within the scope of the duty assumed by the valuer. And we say that obviously HSB's strikeout application was concerned with the question of identifying whether there had been a loss at all, not with the follow-on question as to whether, if there was a loss, the loss fell within the scope of the duty of care. And as this court appreciates, the argument the defendant put forward was simply to say no loss because the payments out had been matched by the discharge of liabilities. And that was the basis of the application, as confirmed before the Court of Appeal in the defendant's skeleton argument before that court in paragraph 9, which we have at page 254. By an application notice dated 9th of April, HSBC sought summary judgment and a strikeout of SIB's Quinscare claim on the basis that SIB suffered no loss caused by the alleged breach. Payments were either not lost to SIB or extinguished the relevant liabilities, leaving SIB's net financial position as it had been before the payments were made. HSBC did not submit that if SIB suffered a loss, then it fell outside the relevant scope, the scope of the relevant duty. Nor was it being submitted that whether or not SIB suffered a loss depended on when the damages fell to be assessed. The simple, straightforward submission of HSBC was identified in the judgment of the Court of Appeal at paragraph 8, which we can see on page 125. Paragraph 8, HSBC submits that the judge ought to have struck out the loss claim because it cannot succeed. The sums paid out by HSBC were debts of SIB properly due to the investors in question, and SIB's balance sheet was unaffected in net terms by their discharge. And that submission is the submission that appears in HSBC's written case before this court, which we see on page 84. Paragraph 29. HSBC's simple proposition is that the Court of Appeal was correct to determine that where payments alleged to have been made in breach of Quinscare duty discharge liabilities, and there's no claim for any kind of consequential loss, there is no net loss because an equal and opposite benefit flows simultaneously from the breach. So we say that's the issue for today, not the follow-on question of whether that loss fell within the scope of the duty owed by HSBC. And confirmation, we say that appears from the defendant's written case at the beginning, page 76. Paragraph 4, HSB says it will be a matter for trial whether on the facts of this case the Quinscare duty extended to refraining from making redemption payments initiated by innocent investors, where both investors and those at SIB who preceded their payment requests were acting on the belief that the business was genuine. And paragraph 5, the issue on this appeal is whether SIB as a company has suffered any loss as a result of those transfers out of the HSBC account. Now, we acknowledge that the language scope of duty did appear previously But that was on the basis of a submission that the duty in question was owed to SIB, the company, and not to SIB's creditors. So it was a peculiar use of scope of duty. And indeed, it was something that has never been in dispute. And we can see that use of the phrase scope of duty in the defendant's skeleton argument before the Court of Appeal. If we turn, please, to page 262. Looking at paragraph 27 to 30, one sees it's headed, the basis of the quid-pro duty as explained by the Court of Appeal in singularis. The duty owed by the bank is owed to the customer and not to the creditors, and only loss suffered by SIB itself is within the scope of the duty owed. None of that has ever been in dispute. But it has not been submitted that the duty owed to the company, it's not been submitted that if there was a loss, the duty that was owed to the company did not extend to the duty of care that was being alleged and which was being assumed for the purposes of the application to strike out. And that's obviously sensible in circumstances where the debate about whether there was a duty of care that extended to these payments was to be had at a later date. Now, we say the issue having been narrowly drawn for the purpose of the application, faced with SIB's description of the loss that it has suffered, HSB has started to slide into a debate about whether the loss that has now been identified clearly, and I'll show it was identified previously, but appears to have been overlooked. But the loss that has now been identified, the response has started to be, well, that loss is outside the scope of the duty of care. So to illustrate that, if we, staying with the written case, if we go to page 82 of the written case before this court, the last four lines of paragraph 18 state, the nature and scope of the quid-pro duty as a matter of law is self-evidently very different from the duty owed by Mr. Stanford as a director of SIB, and that is relevant to the issue of what loss comes within the scope of the duty, and hence to the issues on this appeal. And we say not so. It's relevant to whether the loss is recoverable, whether it falls within the scope of the duty, but it's not relevant to the very narrow issue as to whether there was a loss that was suffered by SIB at all. And similarly, on page 100, these are but examples. At paragraph 79, preserving the pot of assets for the distribution to creditors is the very thing Mr. Stanford was under duty to do in circumstances where SIB was de facto insolvent. That cannot, however, sensibly be described as the very thing that HSB's fundamentally different duty under quid-pro required of HSBC. Again, a submission that may be well-founded, but it's not a submission that we say should be made on this appeal. Now, turning then to the question of whether SIB did suffer a loss, the argument that SIB relies on today was presented to the Court of Appeal. And we can see that from page 281. It's paragraph 32. And the court will see the argument set out in the last 8 lines. If you'd be so kind as to read that. So HSB says, yes, the loss from having the money paid away is matched by the benefit of debts being discharged. And our response is the simple response to say, but the benefit that SIB has obtained is a benefit that it would have obtained anyway, shortly thereafter, but at a much reduced price. And as I say, that submission appears to have been lost sight of and was not addressed by the Court of Appeal, who focused on the argument that was presented in the witness statement in opposition to the strikeout. And we see that argument adumbrated on page 303. This is the witness statement of Laura Jenkins. We see it at paragraph 37D.
I apologise. Could you repeat the page number, please?
303.
303.
It's a sort of rather more generalised assertion that the benefit of having the monies is somehow greater than the liabilities discharged because it could be used for creditors. And that's the argument that's effectively rejected. But the proposition that the benefit obtained by the discharge would have been obtained in any case, but at a much reduced price, is not focused upon by the Court of Appeal. Now, our argument has been expressed in terms of the debts being discharged by the payments would have been discharged by the liquidation, and it's been responded to us that technically the debts aren't formally discharged on the liquidation at all. The debts are discharged and the authorities upon the dissolution of the company. But as we explain in paragraphs 18 to 23 of our reply note, that we would submit it is really a matter of semantics. The liquidation makes debts unenforceable pending formal discharge on the company's dissolution. So the effect is the same. The obligation to pay the debt is an obligation that cannot be enforced against the company. Sorry, it cannot be enforced against the insolvent company. And an obligation that cannot be enforced isn't an obligation in the eyes of the law. We draw the analogy with a debt that substantively still exists, but is unenforceable because it's become time-barred. Payment of a time-barred debt would clearly be a loss. And the position that was stated very shortly in the judgment of the Court of Appeal, which we have the relevant passage at page 130, paragraph 36, quote from Lord Hoffman's judgment in the House of Lords in Buckler as joint liquidators of Leyland Daff versus Talbot. And in the passage that's there cited, one sees at the end the creditors have only a right to have the assets administered by the liquidator in accordance with the provisions of the Insolvency Act. And that means, of course, in substance, that the creditors, upon a liquidation, only have a right to a dividend. They no longer have the right to be paid in full. Now, HSBC, take a more generalised point, they submit that the liability of the bank, HSBC, should not depend on the insolvency of the customer. They make that submission, for instance, at paragraphs 8b and 24. But we would submit that this appears to be another argument addressing either the extent of the duty of the care or its scope. Here, the very breach of duty that is being assumed for the purpose of this appeal arises because of the insolvency of the bank's customer. The duty of care as pleaded appears on page 157. Paragraph 148 at the top of page 157. Sees that the implied term that a bank owes to exercise reasonable skill and care in the execution of its customers' instructions is referred to, and in particular, HSBC was obliged to refrain from executing any instruction, order, or payment request for so long as it had or should have had reasonable grounds for believing that such an instruction, order, or payment was an attempt to misappropriate and or misuse the funds of SIB, or deal with them in breach of trust or breach of fiduciary duty or otherwise involved criminal contact. And pausing there, the court would appreciate that the dispute between the parties about whether the Queen's Care duty of care was engaged at all concerns the claimant's extension of the duty, as the defendant would have it, from cases of misappropriation to cases of misuse. Because I think it's fair to say that to date the authorities in which the Queen's Care duty has been said to rise were cases factually of misappropriation. So obviously the position of the claimant is that the statements of principle relied upon would extend to the situation here of misuse. And then when one looks at what is said to be the misuse in this case, we see that the insolvency is central to the circumstances in which the duty is said to rise and is said to have been breached. Now we can see that if we turn to page 156. I do apologise, 155 first of all. The allegation of what Mr. Stanford is said to have done to breach his fiduciary duties owed to SIB. One sees at subparagraph 1 that he caused and or authorised and or allowed the accounts to be opened and or operated when SIB was insolvent and or in furtherance of the Ponzi scheme. And obviously we make the point that a Ponzi scheme is ex-hypothesi very shortly after its inception going to be an insolvent scheme. And then subparagraph 4, again, he made or authorised to be made and or caused and or allowed to be made and or failed to take proper or adequate steps to prevent payment being made into and out of the accounts in London at a time when SIB was insolvent, and such payments should have been suspended. And then perhaps if you look at paragraph 24 over the page, in committing the breaches of duty set out above and or in operating, causing or allowing the SIB's business to be operated as a Ponzi scheme and or to operate while insolvent, RAS dishonestly abused his position with a view to personal gain and or acted fraudulently. So given a case where the insolvency of SIB is so central to the allegation of the relevant duty and its breach, we would submit it would be illogical to say that a identification of loss that depends on the insolvency of the company is no loss at all. Now, HSB also says that the loss that SIB identifies is not a loss because damages must be assessed at the date of breach. We say that's a rather strange argument in a tort claim, because in many instances the negligence precedes the date of the breach, and indeed, the negligence precedes the occasion of the loss, and obviously the whole debate that was the subject of the Samco decision and decisions subsequent thereto was about the relevance of a post-breach contingency, namely the fall in the value of property. We set out our view of the relevant law in our reply submissions on page 111, and perhaps if you just cast an eye at that. By reference to, this paragraph 8, by reference to the House of Lords decision in Smith and Newcourt Limited and Scrimcoe Vickers, which the court would have read, but for present purposes, direct attention particularly to paragraph 9 and what Lord Steen said. The court is entitled simply to assess the loss flowing directly from the transaction without any reference to the date of transaction, or indeed any particular date, whenever the overriding compensatory rule requires it. So that the stricture is not the date of breach rule, it's whatever the overriding compensatory rule requires. So the real question we submit is therefore not whether the loss claimed arose at the date of breach, but whether the loss identified is a loss that the overriding compensatory rule requires should be taken into account. Once one accepts that SIB has suffered a loss, the question then becomes, is it a loss for which SIB should be compensated? That question is the scope of duty argument put in terms of the date of breach. And that much appears from HSB's own written submissions, if we turn to page 87. Paragraph 39. Breach of the Queen Square duty consists in paying money out of an account when the banker is on inquiry and should refrain from acting on the customer's instruction. Leaving aside questions of consequential loss, the relevant comparison to make when assessing what damage has been caused by the Queen Square breach is the position of the customer as at the time of the wrongful payment, had the money left their account. That reflects the narrow scope of the duty, namely safeguarding the funds in the account, as at the time of questionable instructions received and falls to be acted upon, not assuming responsibility for the present or future financial state of the customer. Well, again, that may be right. We would submit it isn't, but that may be right, but that's a matter to be determined at a later date, because it's not something that was focused on, because of the narrow terms in which the strikeout application was drawn. We therefore say that the date of the breach question is the scope of the duty point, simply dressed up in another guise. If the loss identified is within the scope of the duty, and on the application to strike out it was not being argued that it was not, then it follows that the overriding compensatory principle requires that SIB be compensated for its loss. We also would make the point that in our submission, the data breach rule doesn't really illuminate the issue, since as at the data breach, the insolvency of the company, insolvency of SIB, means that it has the chance of obtaining the benefit of the discharge of the debts at a much reduced price in the event that a third party acts to put the company into liquidation. And that chance is lost by the payment.
Isn't your argument just another way of trying to identify a loss without taking account of the matching benefit? You are saying that it's a loss because the lucky creditors, if we can call them that, were paid, let's say, £100, when in a liquidation they only would have got £5.
Yes.
Well, let's accept all the premises, treat that as a loss for present purposes. Then that is offset, isn't it, by the benefit that the company obtained by settling with the other creditors for a correspondingly, fractionally less amount than they would otherwise have got in each case, which is exactly opposite. And so your loss is exactly cancelled by a corresponding benefit, if you want to look at it, if you can characterise it as a loss.
My Lord, our response to that is that saying that the £160 million that has been paid away would, in any event, have had to be paid away in the insolvency is not a benefit that one has regard to.
Why not?
Because having money, you don't say having money is not a benefit because on the insolvency it's got to be paid to the creditors.
Well, you're trying to have it both ways, aren't you? Because your argument assumes that the company is worse off because it's had to pay out money which it wouldn't have had to pay out in the liquidation. If that's true, then it's correspondingly better off because it saved paying out money in the liquidation that it would otherwise have paid out to the other creditors. If it's not true, then the argument doesn't work in the first place.
Well, we say that there's a distinction in principle between looking at whether there is a benefit in terms of the company still having the money and then looking to see what the company then does with the money. It's never been the case that a defendant could say, but you would have wasted the money that you ought to have had. In the same way, the defendant could never say, it's not a loss to the company because the money is going to have to be paid to creditors.
Yes, but you say you accept the fact that payment of a bona fide creditor and it is met by a corresponding benefit to the company of a discharge of a liability, other things being equal. You accept that?
I do.
Yes. In order to deny the fact that there is no loss in that respect, you have to pray and aid the subsequent liquidation. And Lord Legate's point is the simple point that if you could have paid off that particular fortunate creditor who wasn't the hindmost in the Ponzi scheme, if that is a loss, you have a corresponding benefit that you pay off the other creditors that little bit less. The effect of the company at arm's length with its creditors, which is the hypothesis of your presentation, is nil net benefit, nil net loss.
You're only paying the creditors collectively 116 million, to use the figures in this case, less because you don't have it. And that's not a benefit. Being unable.
But it is in your case. You say you discharge the liabilities to the other creditors for the amount that you pay them. And if you're paying them less than you otherwise would, that's a benefit.
My Lord, it's not a benefit. It's not a benefit that you're unable to pay them. the £116 million more.
Well, then it's not a loss that you're unable to pay the lucky creditors, that you don't have to pay the lucky creditors more. Sorry, I put that wrong, but it's not. But the loss, you have to characterise the loss and the benefit in the same way. That's the point.
Well, I appreciate the point, but this is the point we say there's a fundamental distinction between considering the monies in the company and saying, oh, it's a benefit because the company's got less monies, and therefore, as a consequence of having less monies, it pays less monies out. We say, but that's not a benefit at all. As contrasted here, where we say that the loss is the monies are being paid out. That's the analysis that's been accepted. The respondent says, no, but that loss is matched by a corresponding benefit. And we simply say the corresponding benefit is a benefit we would have had anyway. The benefit of the discharge of the debts is something we would have had in due course. And therefore, unless one says one can't look to see what the almost inevitable consequence of the insolvency company is, then there has been a loss.
Well, the benefit which you would have got, i.e. the privilege, sorry, to start again, you're looking at the position of the company at arm's length from its creditors, and you are saying that the company could have discharged this creditor's debt for a smaller sum than it did, and therefore we've suffered a loss. But the difficulty with that, if you're looking at the company at arm's length from its creditors, is that the only way it could discharge the debt at a lesser sum is in the context of its winding up and dissolution. And as you concede, it would not have given rise to any formal discharge of the debt. You say as a matter of substance, we have to look at the fact, well, it wouldn't have had to pay out more. Now, if the consequence, treating the company at arm's length of its creditors, of paying too much to A means that you pay less to B and C and D, where is the loss to the company?
Well, because we are focusing on the particular payments that were made. The benefit that's been put in response to the point is the benefit that arises out of the insolvency, irrespective of the impugned payments. The creditors get less because of the general operation of the insolvency as a point separate from these particular payments. So it simply follows from the fact that a company can only pay out what it has. If the company has 116 million less, it pays out 116 million less. If the company has 400 million less than it might have done from some other business transaction, etc., it can only pay out a sum that's 400 million less than it otherwise would have been. Well, that's a generalized operation of the law of insolvency, separate from these particular payments. The point about these particular payments is that the money's gone out, and it is said by reference to these particular payments, but you've had the benefit of these particular debts being paid. And we say, no, these particular debts would have been paid off, would have been effectively paid off in any case, but at a fraction of the price.
But that,
so
for the unlucky creditors, you would have to have paid them more in order to discharge their debts on dissolution, in order for their debts to become discharged on dissolution, than you in fact had to pay them.
Yes. Yes.
Right. So that's, I think, the point is being.
But that, yes,
that's
this comes,
please interrupt me. That is a corresponding disadvantage that you gain from the supposed advantage of not having to pay the lucky creditors so much.
But we submit it's not a disadvantage that the court should have regard to, because it's a disadvantage that rises from the company having fewer assets.
Well, either you take that into account for all purposes or for none, and your argument is simply an attempt to have it one way around when you're looking at the lucky creditors and the other way around from the other payments. It's as simple as that.
Well, we submit there's a ready answer to the notion that paying creditors less is a benefit when one considers that that's a consequence of having fewer assets. Having fewer assets is never a benefit.
Well, then it's never a loss either.
You have fewer assets and you have fewer liabilities. The only way you discount the benefit of the liability is by praying in aid the winding up. And when you pray in aid the winding up, you have to look at the whole picture. Creditor A may have got, if creditor A hadn't been paid out, then creditors B, C, D, and E would have got more. The position of the company at arm's length with its creditors would be precisely the same.
Well, in the context. But the response that's been put to me comes back. I know my Lord Legate says we're wanting it both ways, but we say we're entitled to have our cake and eat it on this, because the counter argument is simply a reformulation of the fact that the company has less money. Our basic loss is the company has less money, and that should not be recast as, oh well, aren't you lucky? Because that means that when you go into insolvency, you get to pay out less. We say that would be perverse. But there's nothing perverse about responding to the fact that we have less money by pointing out that the alleged benefit of paying off the lucky clients, the lucky customers, is something that would have happened anyway in short order.
Well, they wouldn't have been paid off. You just would have been entitled to write off, as it were, a large part of your debt to them. Well, corresponding to that, you've saved having to write off quite so much to the others, owed to the others.
Well, my Lord, as I say, we still say that last step is an impermissible step because it's simply a consequence of the company having less money. Having less money for the company is never a good thing.
And you distinguish having less money from having fewer assets?
No, I don't. I just say...
You distinguish it from having fewer net assets?
Yes.
Your complaint is we didn't have cash to pay 6p per pound in the pound to the creditors rather than 5p in the pound. But given that the whole hypothesis is that the company is at arm's length with its creditors, why does that matter?
Well, I accept that's not the concern. The concern of the company is precisely that. It's not concerned with what the creditors get paid. The concern of the company is simply with how much money it has, and it has 116 million less. And as I say, the response to that of saying, but this, you no longer have to pay these creditors, we say, well, that is a situation that would have arisen in due course, and we would not have had to pay them the full value. The legal obligation would then have become to pay them the dividend. And if you look to see what ought to...
You've saved on one dividend and you've lost on other dividends, and the company has, and they balance out.
Well, my Lord, I think your Lordship has my submission that final stage is a stage that should not be taken, because it's presenting the company having fewer assets as a benefit, which it never is. In our submission, it's perverse to say that it is a benefit to the company to have fewer assets on a liquidation than it otherwise would.
But that's not the benefit. The benefit on your analysis is that it's able to pay a smaller dividend than it would. It doesn't have to pay such a big dividend as it would otherwise have had to done.
As I say, that's a general observation in respect to the liquidation generally. In the context of these payments, these particular payments, the response to the loss going out is that these particular debts have been discharged. And we say to that, well, these particular debts would have, if I use the shorthand again, been discharged in due course. And therefore, it's inappropriate to say that there's a matching benefit.
Why is that inappropriate, sorry?
Because the benefit that's been identified is a benefit that would have accrued due as a matter of reflection of time. On these particular payments, it's the same, we would say, as if the debts that had been paid were due to become time-barred in short order. So looking at the payments that are the subject of the claim, there isn't the corresponding benefit from the debts being discharged, given the imminence of the liquidation. And one doesn't then go on to say, but once one's in a liquidation, it's somehow irrelevant that you've got fewer assets, because those assets would have to be paid out to creditors. Because that's not a consequence of these payments. That's just a general statement of the position. And it's perverse to say, well, because the company's got fewer assets, that's a good thing, because it's matched by the fact that it makes fewer payments to the creditors.
But the difficulty, of course, is that in order to establish a loss, you have to pray in aid the fact that you could have paid a smaller dividend.
Well,
I mean, absent the argument about a smaller dividend, then surely the fact that the creditor, the innocent creditor of SIB's Ponzi scheme, the fact that that his or her debt or its debt was discharged would have a nil effect on the company's balance sheet. You say you can't get off with that because we have this imminent winding up, and we could have paid less. Now, if you have that, you have to look at the whole consequences of the winding up, don't you?
well, it might, for the reasons, whether they accept it or not, for the reasons I've sought to explain, we say not. My lady. I've just been a point of repetition, I fear, if I were to pursue the point.
No, sorry, I must allow you to develop your argument.
No.
Well, this is really it, isn't it? I mean, either it's a loss or it isn't, the way you put it.
Yes, we may be going home early, yes. Moving on, as I say, I've made my submissions. The court can consider them at leisure and decide whether there's any merit in them. There's a pleading point that's been taken against us. It is said that we should positively have averred that the debts that were paid out of the accounts would have remained in existence and would not have been paid out of other accounts had HSBC refused to pay them. We say that it's a difficult argument to follow to say that HSBC is not liable for causing a loss, because if HSBC had not caused the loss, some other bank would have caused that loss. So we say legally it's misconceived.
And if that were a defence, it would be a defence even if the transaction on which the bank paid out was clearly a sham. If for example, in the Singularis case, if the company had had other bank accounts which had money to their credit which could have been used to pay same sham demand as Dai were paid, then each of the banks could say, well, the other one would have paid.
My lady. But we say in any case that even if it were legally relevant, as a factual proposition, it was for HSB to plead and prove it. It's not for the claimant to plead the negative. And finally, there's the point that in any event, the factual averment that the debts would still have been paid by someone else is now an issue in the case. It's been factually averred by the defendant, and the reply is taking issue with it. So
it's not a matter for the strikeout?
Indeed.
No.
There's a sort of timing point that's raised at page 86. They say, well, if you look at the payments in August 2008, effectively they're a long time from February 2009, when the receiver was appointed, shut down the accounts. But we say, well, that's not a point of principle in opposition to what we say. Whether or not there's some suggestion that the chain of causation becomes too attenuated between August 2008 and February 2009 or April 2009 is a matter for the trial judge. It's not something for this court to decide. And your Lordship, some lady will have seen that we have sought to buttress our submission by pointing out that the Court of Appeal has proceeded on the basis that payment of a debt in breach of a duty by a director does give rise to a loss in the West Mercia case. Now, this is really for the purposes of saying that the issue that this court is addressing isn't an issue confined to cases involving the Quinscare duty, but it's an issue that does arise in the context of preference payments by directors. If we look at the West Mercia case, page 8845, this is where the director caused the company to make payment of £4,000 to the parent company in partial discharge of a debt that the subsidiary owed to the parent company in circumstances where the parent company's overdraft was thereby reduced by the £4,000, an overdraft that was guaranteed by the director. And if you look at the bottom of page 847 in the bottom of the right-hand column, at first instance, the claim was dismissed on C's, the bottom there, last paragraph. The judge nevertheless felt that although Mr. Dodd had acted improperly, he had not misapplied any assets of West Mercia Company because he had used the assets merely to pay in part a debt owed by the West Mercia Company to the Dodd Company. He therefore concluded that he could not see that Mr. Dodd had been in breach of any duty of care fiduciary or otherwise to the West Mercia Company or in relation to that company. So the issue before the court was foursquare raised in West Mercia, and the judge at first instance had taken the view that HSBC take no loss. But the Court of Appeal overturned the decision and held the director liable to repay the £4,000. Now, one sees on page 850, he deals with Lord Justice Dillon deals with the windfall that would otherwise accrue to the creditors because the liabilities has been reduced by £4,000. And then, in the penultimate paragraph of the judgment, there's what's become known as the West Mercia proviso, The appropriate course of administration in the present case is to order Mr. Dodd to repay the £4,000 with interest and to direct the distribution of the assets of the West Mersey Company to unsecured creditors. The debt due from the West Mersey Company or to the Dodd Company is to be taken as notionally increased by £4,000, or what it would have been if there had not been a fraudulent preference, and any dividend attributable to the extra £4,000 thus added back to the debt of the Dodd Company to be recouped to Mr. Dodd rather than having been paid to the Dodd Company, since that's a rough and ready way of achieving justice on both sides.
If the people who had been paid off here had been preferential creditors who were entitled on a liquidation to be paid in full in priority to the other creditors, what would be the effect of that on your argument?
If the assets were sufficient to pay off the preferential creditors, then I would accept that there was no loss, because they would have been, you'd have had to pay the full amount in any case.
But doesn't the, I mean, is the bank then expected to inquire as to whether the people being paid are preferential creditors? Or if the bank had stopped those, put it the other way, if the bank had stopped those payments because it was worried about the insolvency, but those people were on an insolvency anyway entitled to be paid in full, was the bank entitled to do so?
Well, this comes down to the particular details of what would be a breach or what would not be a breach.
Yes.
Rather than the question of loss. But your ladyship's basic point that if the payments had been to preferential creditors, then the argument identifying a loss in the way we have done falls away. That would be right.
But presumably you would say, if one's just looking at the question of loss, if there isn't enough in the pot to pay off all the preferential creditors
then
pound for pound, then there would be loss, you say, to the extent that the assets were not sufficient.
That's right, yes.
So you say it would still, well, what do you say? Do you say it would still be a breach of the Quint's Care duty for the bank to make that payment, even though it didn't result in any loss, on my supposition that the people who were paid by the bank would be paid 100 pence in the pound anyway on a liquidation?
Yes. I mean, if the circumstances of this case were to be that a number of the creditors had been preferential creditors, then it wouldn't really matter whether or not there had been a breach, because there'd be no loss, subject to Lord Sale's point as whether the assets sufficient to pay off the preferential creditors.
Assuming they are.
But prima facie, one anticipates that given the context of these particular payments being in the context of money laundering, one might expect the court to consider that the duty of care was coextensive with the money laundering obligations, in which case the precise nature of the debt that was being discharged might be thought not to be relevant. But as I say, these are principally difficulties to be addressed in the context of arguments about whether there was a duty of care and the scope of the duty of care, and whether there are any exceptions depending on the nature of the payments. So the nature of the creditors.
If the bank had refused to pay off the creditors because of anxieties about the solvency of the company, but those were preferential creditors who were entitled to be paid and would have been paid in full, suppose the failure to pay them by the bank increased the interest charges or gave rise to a liability, to a penalty of some sort because of the non-payment of those debts when they fell due. Would the bank then be liable for that loss?
Well, I think isn't that the argument? And forgive me if I'm misrepresenting it. Isn't that the countervailing argument as to why the bank says that the extension that we seek in this case is unjustified because the primary duty is to pay on the payment instructions or face a claim for damages by not paying. So that is the primary duty, and obviously we seek to identify circumstances in which that primary duty is displaced.
Yes, but you're also saying, I think, that there is a breach of duty because there might in some cases be consequential loss, even if there isn't the loss that you're pleading. And consequential loss isn't claimed in this case, but I'm trying to think about whether there could be circumstances in which there is consequential loss, but not the kind of loss that you're claiming.
Well, in terms of consequential losses that SIB could have identified, I think what people have had in mind in that context is to say, well, the net deficiency of SIB at the time the account should first have been frozen has increased by its continuing to trade because the accounts weren't frozen. So it was, sake of argument, the deficiency was $1 billion in August 2008 when the account should have been frozen, and the deficiency was $5 billion by February 2009 when they should have been frozen. And I think that's the sort of consequential loss that people have had in mind when they refer to the fact that no consequential losses are claimed in this case. And that's because the claim in this case is predicated on the failure on the failure that was constituted by acting on the payment instructions. So the immediate loss is the money that's paid away. Looking at West Mercia reminds me that in terms of quantum, and responding to Lord Legate's point, in terms of the money would have been, you pay less to creditors. If you have the 116 million still in the company at the point of liquidation, it obviously is available for liquidation expenses. So in terms of the benefit to the company, it's not wholly matched by the benefit of not having to pay creditors 116 million, because it's available generally to the company, and there isn't the direct correlation. Obviously, the quantum of the claim on that analysis is substantially reduced, but there isn't that direct correlation. So in addition to the points of principle, there is what one might be said to be the mathematical objection as well.
But is it suggested that there are no assets whatever available for distribution to creditors because they've all been swallowed up by liquidation expenses?
Don't think so, no. And the position under the West Mercia proviso is that the defendant is given the benefit of the dividend that would otherwise have been paid on the debts that have been discharged, which is something that we take into account in our calculation of the loss.
Sorry, could you just say that again?
Under the West Mercia provision, the defendant who's having to pay the amount that shouldn't have been paid away is obligated to repay that sum, but is given the benefit of the dividends that would have been paid on the debts that were discharged with his payment. And obviously, we rely upon West Mercia as saying that this is a case where the Court of Appeal, having rejected the decision, the first instance decision, was necessarily by implication accepting that the company had suffered a loss. Now, quite why the company had suffered a loss is not identified, that's fair to say, but it isn't the explanation for the decision that was put forward by the respondents that, well, this is an application under the misfeasance statutory section of the Insolvency Act, which enables the court to give discretionary relief, not untrammelled by the restraints of having to find that the company had suffered a loss. Now, we responded to that by saying, no, section 212, which is the modern section, it's accepted that that section only applies to causes of action that exist aside from the section. And because it's necessary to show a loss for there to be a claim, the Court of Appeal in West Mercia must necessarily have been taken to have found that there was a loss.
And what do you say the loss was in West Mercia?
The loss that I sought to identify, namely that the debt that was paid is a debt that would have been paid, the debt that ceased to be payable would have ceased to be payable in short order.
When you say in short order, you mean on the dissolution of the company?
Oh, well, I mean on the liquidation, because the debt ceases to be payable, although on the basis of what Lord Hoffman said in Wright and Eckhart, not formally discharged. No, I'm not. I'm spending time on this, and just to make it clear, I'm not suggesting that your lordships and my lady will necessarily derive a great deal of assistance from the consideration of the authorities that we're looking at. This is really for the point of making the point that the problem that the court is grappling with is not confined solely to issues of the quid care duty. It is a problem that needs to be